Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dahil mihi Anglican boys, nervous like
Oh, for crumb's sake.
I didn't ask you to interrupt me.
It's Monday. It must be Monday, right? I think it's a Monday. All right. Welcome, welcome, welcome. Everyone, please come in. Take your seat. Take your seat. There we go. Let's move this over here. That there. One, two, three. There we go. All right. We are good. We're good. Welcome, sample user. It's a sample user on my screen. Every time I boot up, it's funny that it does that. All right. First and foremost, welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. I'm like twice the person I was last week. I feel that much better. I realize if you listen very closely, there's like just a little bit of gravel in the voice that it just doesn't go away. But I feel so much better, which means the meds have kicked in. Oh, no, that's on the wrong screen. Let's see. Thank you, little RA. Did you bring me some water? I will need it. 1, 2, and 3. There we go. 3 waters should be able to get me through most of the day. What's that? I'm not showing up on my screen. Is that better? Thank you. Good morning. Good morning. Welcome. Happy Monday. This is... If I did my math right, this is Thanksgiving week. And for those of you overseas, might not make much sense, but those here in the United States, Thanksgiving is a big holiday. It's a big holiday where we celebrate food and eating food and making food and letting other people eat our food. That's basically, is that right? No, just kidding. It's a holiday that stems from early settlers in the United States, who apparently had a rough go of it. Also, the story is that they had a rough go of it, and the Indians helped them out, showed them how to, plant and harvest and grow corn and everything else. And that first harvest season they celebrated. That's the story behind it. Whether or not it's true, I will leave to the scholars to decide. Anyway, it has grown into a turkey fest. Is probably the best word for it, where we everyone cooks a turkey. And some do it poorly, and occasionally get a few people get food poisoning, because raw turkey is not like a raw, rare steak. Rare turkey is bad. Anyway, so others cook them phenomenally, and, you can smoke them, you can cook them in the oven, you can deep fry them. There's a million ways to cook a turkey, and then everyone eats it, and everyone goes to sleep afterwards because of the tryptophan. All right, that's I'm not sure why I went on that little rampage or little sidebar thing. Let's see. Now it's working. Krista, welcome. Krista, we say welcome to you because you were first in chat today. First in chat has the privilege, the pleasure, the punishment of being. Let me move this right here. There we go. Of being recognized first and foremost above everybody else, which congratulations, that's you, but also being punished with internet ownership. So you're responsible for keeping everything internet connected, IP related, running worldwide. So just get right on that and we'll be good. I think the seats are broken, says Tammy. Let me check and see what the seats are doing. 1 second. It did not engage. Let me try this again. Everyone's standing. I was wondering why everyone was standing. Let's try this again. Launch. There it is. And connect. No. Stream is offline. I show I'm online. Let's do a quick little. Oh, nice. There's an update error. We have a raffle option. That's cool. Hold tight, hold tight. Let's see. Default state, connections. Why? I'm going to try turning it off and on again. Otherwise, Krista, this is going to be your responsibility. You're going to have to get this fixed. Chatbot's not engaging. Control center. Let's do some quick settings. API. They've got raffle stuff. I'm going to have to look into that. That's really cool. Okay. Hold tight. This is you guys are talking amongst yourselves, and that's the appropriate thing to do in this moment. But I need to get this fixed here. That's a little frustrating. Connections. YouTube. I'm going to try turning it off. Try turning it back on. Refresh. Why would it lose its connection there? I go back to my dashboard. You guys are going to have to stand all day long. This is, I can't think of another solution right now. Standing it is. Oh, I know what I can do. Hang on. This might be a bad idea. I'm going to delete my connection to YouTube. And then add a new connection to YouTube. Next, yes. We're going to connect to this account right here. Continue. Connection successful. Okay, now where are we? Let's see. Bring that back up. Oh, now give it a try, huh? Give it a try. Krista, I didn't need your help today. I did it on my own. I'm actually going to turn it off and turn it back on one more time just to get it to cycle. Close that down. Happy Monday, by the way. This is a typical Monday occurrence. I'll be able to read chat in just a second. But YouTube. Still no chatbot. Why no chatbot? I have ChatGPT, but I don't have a chatbot. So there's an update error. Okay, it's working a little better, but it still is not working. So I don't know. Krista, I am going to pass this one over to you and say fix my internet. I don't know what to do. While this is going though, however, let me just say, Kennedy Smith gifted 5 memberships this morning. Great way to start working. Yes, Seed is not working. Nothing is working. I'm barely working. Apparently, I take a couple days off and the whole thing just falls apart. Let's see. There we go. Petrified is going to stand by choice. There we go. Well, I'll see if I can get this working. My computer's definitely sick. I think I passed it to it. Yes. I'm going to just say, please be seated. Everyone's able to be seated. Remember, there is assigned seating, even though I can't enforce it this morning. So if I see somebody in gray on the front row, I'm going to have to move you back to the back, and vice versa. Update needed. Yep, update needed. And my voice is doing that thing again where I don't want it to do that thing. I will tell you, my system needs to be updated quite badly. It's told me that for about a month and a half, but I don't want to because when I update things break. K Scarpetta, welcome to the gallery. Thank you very much. Yellow Courthouse. Love that. Love the support. Thank you. What's the point of seat anyway? It's when you come into court, typically you want to be seated instead of standing the whole time. That's it. Oh man, I just looked across my room and way over there behind my computer on the floor is the remote I need right now. And I may have done it's like a no pants week, and so I can't. Hold on one second. Paging little RA. Thank you. All right, it worked. I needed a grabber stick. That was like 8 feet away, though. That's about as far away from me as it possibly could get. Let me tell you what's happening this week. There's a couple court cases still going on. We've got like Melly, always and forever and again. I think we have a couple court cases that are ongoing that have been happening for quite a while. But I don't think we have any new court cases starting during the holiday week that I'm aware of. So we just have little court cases, and I'd love to start a new court case or a big news story either way. But so far we haven't had anything pop up that matches our schedule. So it's going to be another court hopping day for that, unless somebody has some great suggestions about which cases we can follow. I'm missing an iPad. Do you call them Little RA and Mrs. RA off stream? No. Did I say? Did we do birthdays? I've not done birthdays on Thursday. Is it Angela? Is it pronounced Angela? I think it's Angela. We'll have to sing on Wednesday. Let's see one second. Who said this is the first time we've seen blinds in my room? Yes, I do have blinds. I have shutters, inside shutters on these massive windows. Every window in my house, what you can see, that's a little less than half the window. They're tall windows, and they're built in 1915 with the original glass, and every single one of them needs to be replaced. I have 33 of them. So if there's a window company out there that wants to sponsor the show, it will be equivalent to buying my house again when I replace the windows. Let's see, I'm feeling better. My voice it does this little crackle thing. It'll probably do it while we're singing if we have any birthdays today. We can just all celebrate my birthday with me today if that works. Party time. Created by EJF. Is that your birthday today? Are you one we should appropriately celebrate? EJF? I've got to turn it off and on again. That's probably the case. See, my son used this computer for a meeting over the weekend, and everything was changed. To cover the last Murdaugh hearing, no. Brandy Churchwell's been covering that very well. Basically, he's complaining. I watched a little bit of it. They're complaining a lot. They're complaining they want Judge Newman off. Speaking of judges, Did Judge Schroeder retire over the weekend? Is that what I saw? Did anyone else follow that? I think Judge Schroeder retired, and he's the one that
I didn't ask you to interrupt me.
Sorry, that we got so many good comments or quotes from. Christine, we missed yours. We're going to add you to the list. Seat Command is not working for anyone right now. I've got to work on it. Yes, he retired. Maybe now we can get him on the show. What do you think? Would that be something you guys would be interested in if I could reach out to him and get him on the show? Of course, I would have to ask him the question. It's like, Judge, when you scratched your head, were you reading our chat? I don't know. That would open up a can of worms, wouldn't it? Let's see. Mayla's mom. Did you see the new case where the woman stabbed her boyfriend and she's only charged with involuntary manslaughter because of Mary Jane? 108 times. 108 times she stabbed her boyfriend. After 3 puffs on a bong, apparently. And she was in a psychotic state. Crazy, crazy, crazy. Iris D. Oh, my goodness. Yes, yes, yes. You know. You understand. Our house was built 4 years after yours. It is an amazing house. It's beautiful. The stained glass is beautiful. The crystal windows are amazing. The little sunrise thing over the door. It's incredible. I love the huge wraparound porch. I love so much about my house. Other than the fact that it was built in like 1915, over 100 years ago. And the roof will cost me about $30,000 to redo, and the windows will cost me about $30,000 to redo. And pretty soon you're talking about buying a whole new house. So it's crazy. But our Airbnb is almost done. We just have lights to put up because we failed our inspection. I told you this, right? Quick story. We failed our inspection. The final. Even though we passed all the preliminary, we failed the final, and we failed electrical on the final because we didn't have a socket, a grounded socket, close enough to the sink. Seriously, we didn't have a socket close enough to the sink. Even though we had 3 sockets up there, we have to put another one up there. So we put that up over the weekend. Just we had to cut through the tile, backsplash, run cables down through the wall, all sorts of stuff. So we put that up, did that wiring, and we thought, well, we're in here, let's fix a couple other things, because we have a little 3-way switch with the kitchen light that I didn't like how it was working. So we switched out, we ran more cables, so that the outdoor light wouldn't be on the same circuit as another one. And anyway, but now we have all the cables in the wall, and now we have to figure out how to wire them correctly so the switches make the lights work, which is really like a guessing game. Unless you're really good at electricity stuff, and I'm not. So it's like, okay, plug it in. No, that wasn't it. Unplug it. Turn it off. Turn it off. You know, that's what we're going to do. Well, just over and over, and try not to zap ourselves in the process. Everything else, we went out. We bought the new area, the floor rug. Looks beautiful. I like that one. Would there be grants to help with the restoration of old homes? We have that here in Canada. Hollymac, there are, but only if you sign on to an agreement to restore it like as original, where you have to, hand plane the wood and everything else. It's ridiculous. It has to be like the original look, and I want to update it. I want to change it. And we've already updated our kitchen completely. So I don't think I'm eligible. Plus, I'm one house away from the historic district. I'm not in the historic district. It starts partially on my property, but I'm not officially in there, which is a good thing for me. Okay. Yeah, the dude, the inspector, he comes in first. He gives us that problem, and then he says also, he's like, how can you guarantee that you have 220 volts of electricity coming through here? I'm like, I don't even know what that means. Like, how do we guarantee? It's the wiring's there. It's got all the wiring's correct. And he's like, since you can't guarantee the math on it, you need to add another ground rod. So you have to buy like $100 worth of copper and hammer it into the ground next 6 feet away from the existing ground rod that's already hammered into the ground. So we've got 2 ground rods now. And he said we had to use some spray foam around a little place where a pipe came through the wall. So we had to, do all that. What else? Anyway, lots of things we had to fix. All right. Seat is not working, unfortunately. We'll try to get it fixed. How many people can stay at your place? It has 2 queen beds, and we may add a couch pull-out at one point, but right now it's just a couch. So it's very comfortable for 2. It's 800 square feet. 2 people is very comfortable. 1 bathroom. And I took some pictures as well, so we can get ready to start posting it. You can get a voltage meter and show them what's coming in. I could, but I am scared to death of electricity. Jim Bob, I thought it was ridiculous. I think it's just a money grab, because if he has to come out again, we have to pay him another $75. Let's see. I did not see the picture of Judge Carroll. Let me take a look really quickly. And you put it on, you said you put it on Facebook? I'm about to do a poll, by the way, so don't go anywhere. We're going to do a Thanksgiving poll. Let's see. Hold tight. Has it been approved yet? I'm just looking. I don't see it. Okay, well, we'll sort that out in a bit. I can't see it right now, but I'm terrible at Facebook. It's like my least good thing that I do. Sharon did send me the list of birthdays. I missed it. Hold on. Let me scroll up. Sharon, I trust you. I just missed it. Let's see where it's at. Selena K says, I'm so glad that I'm back in green. I love that I've been here for 7 months. Selena, thank you very much. It's been a wonderful 7 months. Wouldn't be the same without you. I appreciate that. Here we go. Let's see, tomorrow's the paramedics trial. I did not see the list. Did you send it? I can't scroll very far back. Do we have anyone else? Did it come with fiber? I've run Cat. Is it Cat 6 or Cat 7? I forget. The one with the ground wire. Insulated, individually insulated and collectively insulated, and a ground line as well. Is that Cat 6 or 7? Let's see. Looking for the birthdays. I know I can't forget. Oh, Sandy has a birthday as well. Give me a second. Is there any others? Hey, Sharon, can you send them again? I cannot see the birthdays. And when you say you sent them to me, did you send them to me in chat or in like mod chat? I'm not seeing it at all. It's not in mod chat. Would be interested in covering the Tracy Ferreter case. That would be so cool. Marjorie, tell me a little bit about Tracy Ferreter. as I Google as well. It's a custody thing. Okay. Michelle, mine was yesterday. I'm seeing little messages come in. I'm just not seeing the big one. Kids are running in and out. Playing with the cat. Up. There it is. Up. Okay, so there we go. I don't know why the buffer sound isn't working. Sorry about that. Sharon, thank you for sending those again. Okay, so I've got EJF, Christine, Sandy, and Michelle. Oh, and Meg as well. Okay. You guys ready to sing? I'm gonna go easy on my voice. Oh, that's why the name sounds familiar. The Boy in the Box's mom. Man, that is a tough one. Brandy's going to do that one. If Brandy's, let me see what else is available. I like to do a different one than Brandy's doing if I can, just so you get some variety and options. Plus, I don't like, it turns into a who wore it better contest, and Brandy always wins. So, okay, so we've got a couple, and Morgan. Okay, so Morgan. All right, EJF, Christine, Sandy S, Michelle, Meg, and Morgan. Those are our birthday people today. All right, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, EJF, Christine, and Sandy. Happy birthday to you. I've lost that lower range. Let's see if I can get it back here. Michelle, Meg, and Morgan on verse 2. Happy birthday to you. Happy birthday to you. Happy birthday, Michelle, Meg, and Morgan. Happy birthday to you. There we go. We got everybody in. EJF, Christine, Sandy, Michelle, Meg, and Morgan, and anyone else who's celebrating your birthday. Thank you very much for being here. And hey, sing louder in the back, says Samantha. We can't hear you back there. Have a happy birthday, all of you. I appreciate you guys being here. Of all the many places you could be, I'm glad I can celebrate your birthday here with you. So thank you. Have a happy birthday. Get yourself some free pancakes. Jovi Ray, happy birthday as well. That is awesome. Happy birthday to everyone. So I was going to do a quick. Pickles' sister as well. Lots of birthdays this week. We will give everybody a good cheer as well. Happy birthday. You guys deserve it. All right. Let's see. Bug Dugger says, I like it when you both do different trials because then I have one to watch during the day and one in the evening. Okay. Speaking of what you guys are doing, Bug Dugger, it's a little bit of a hard transition here, but you reminded me of it. So let me do this really quickly. Today is Thanksgiving week. All right. And for those that are celebrating, we're going to do a quick poll. I spelled every single word in that incorrectly. And I was spelling, what are your, and I got all three words wrong. Okay. Okay, here we go. Almost done. Okay, here we go. Our question is, what are your Thanksgiving plans? If you're celebrating, or if you're not, you can also be included on here. Let's see. Our options are family coming to visit, going to visit family, celebrating alone, or bah humbug. I think you guys know what bah humbug means. Tammy says, good morning from Niagara Falls, Ontario. Welcome. Good to see you from the high side of everything. You're up above, right? Because we're down below. That's it. I've never been there. I've never been to Niagara Falls. I've only seen it in movies. Thaw your turkey, y'all. Yeah, thawing a turkey, that's like risky business. If you start too soon, like the meat spoils, right? If you start too late, you spoil. Our Thanksgiving was last month. Canada in the house. Kathy, we have a lot of people from Canada that I think we noted when it was Canadian Thanksgiving, but it was a regular work day for us down here. Hosting and roasting a chicken instead of turkey. Tisha says, I'm inviting all chat to my house for Thanksgiving. Since I have your address, I'm just going to go ahead and post that now, Tisha. No, just kidding. That would be really, really mean. Home alone packing as I'm getting evicted. Oh, no, Paul. Oh, no. I am sorry. In which state are you located? Bah humbug. It's like a saying from the Christmas Carol movie. It's like Scrooge says bah humbug, right? Because he doesn't celebrate the holidays. We're hosting a community Thanksgiving. I'll have photos to share on Discord and Facebook. That is awesome. Inviting people from the community. That is really cool. Celebrating with my son, making a pork shoulder. Mom's making ham lasagna. Thanksgiving lasagna. That should be a tradition. I would sign up for that. Okay, we're going to do a quick end of the poll here. You've had moments to vote. So in about 5 seconds, we're going to end and see what we've got. What the predominant decision is. All right, so 40% of us, or 39%, are going to visit family. 23% are celebrating alone. 23% have family coming to visit, and 13% of you just have zero celebration in you whatsoever. Bah humbug. All right, so interesting numbers. I think we're in the celebrate alone category because we live so far away from any of our family that no one can come and visit. So we're with the 23% that are celebrating alone. Maybe we should do something on Thanksgiving to celebrate together, all of us, just so we can. For those that are celebrating, just for, not the people that are going to family, not the people that have family over. I don't want to take you away from your family at all. But for those of us that are celebrating alone this year and don't have anyone coming to celebrate with you, maybe we should do something together where we can just have a moment of a little celebration, Thanksgiving celebration. Yes, we do have trials coming up. Just not sure which one yet. There are a couple. Honestly, the trial out of Colorado that we followed previously, where we had the access from the court. It's the same sort of setup for the paramedics that are being tried in the Isaiah McLean murder, and it's awful. It's just very difficult to watch. The court does a very poor job of lining up, starting the streams appropriately. There's no notification. It's brutal. It's brutal on me trying to follow that one, so I'm not following that one. They make it as difficult as possible, intentionally. Let's see. Thanksgiving is going to be on Thursday. Very British. We celebrate. It's always on Thursday, and it's always, I believe, it's the fourth Thursday. Do the math with me here. I should know this. 1, 2, 3, 4. I think it's always the fourth Thursday of Thanksgiving, of November is Thanksgiving. It's one of those holidays that has a weird rule, right? But it's always going to be on a Thursday. Okay, I think we've given the courts significant time to wake up and see if we have anybody who's up and about this morning, so we can see if we can jump in with an existing little docket of something. Let's see. Who is up today? What? Say it ain't so. Oh, that was a year ago. Like Pike County, that shouldn't be on there. Got a couple news stories that will definitely turn into a murder trials. Paternity court? No. Let's see. Judge DeSanto's live. Let's hear what she has going on.
I have a better understanding of it now.
Okay, and probation can answer more of that in detail for you, okay?
Okay.
All right. Okay. $300 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $300. I'm sorry, that's $50 a month at 12 months. And since you're eligible for early discharge, some of that may not be due. So up to $300 of that may not be due. $200 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Workforce is $200. That's 5 days at $40 a day. Chemical awareness program $75. For a total of $1,600. And you did post a bond of $250. Do you have any other money that you can pay today, sir?
At this moment, no. It wouldn't be until Friday, maybe at the earliest.
All right. What type of payment plan can you would work for you, sir? How much per month and what day of the month works best?
I get paid in 2 weeks, so it will be this week and 2 weeks from this week. So, what's the total? 1,600.
Yes.
I can.
Can you do $100 per month?
Yes, I can honestly probably do. Honestly, I'll probably do at least. I can do 200 per month. That's fine with me.
Okay. So right now, let's keep it at 100. If you want, if you can pay more,
That was
you can
nice
pay
of her.
more. We don't have a prepayment penalty. Okay.
Okay.
So.
No
all right. So
no prepayment penalty for
is,
court costs.
Applied from your bond. Let's do the balance of $1,350. That will be payable $100 per month beginning. We'll begin at December 1st. Okay, sir?
December 1st. Okay.
All right. All right. Please email into probation as soon as you're done here, and they will get you set up with your terms and conditions. Okay?
Do I need? So, probation officer, she gave me her business card. That's what I need to email.
Yes.
Okay.
Yeah. So, all right, and then the court will, as I did indicate, you're eligible for early discharge, sir, so long as all the following have occurred. You complete at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you made a good faith effort toward making full payment. Okay, sir?
Okay.
Okay. All right. Anything else?
Will
I'm sorry, what was that, sir?
I get an email copy of all this? So just in case I do forget.
when
Just
you
in
when you
case
give
I
your
forget.
information, they're going to set up an appointment so that you can receive all of your instructions and any.
Okay.
Sorry.
No, I'm fine.
Okay.
Nothing.
This is something you should probably write some
Thank
notes
you.
on, buddy. Should probably scribble down
Good
some
luck to you,
notes.
sir. All right, let's go off the record. Have a good day.
All right, you too. Thank you.
Okay. All right. The is that Miss Baumgarten or is it Miss McKenzie?
No, this is Miss McKenzie. Miss Baumgarten was also at Genesis 3, so I think it's still registering her name.
Okay, that makes a lot more sense because
I'm sorry, I had to come in. I had to come in. She said they hung up on me. I said, wait a minute.
Well, because I kept calling her, I kept saying Miss Baumgarten, and she was not responding. So that would be why, because that is not her.
Right.
So,
I'm sorry. I apologize. We'll take the name off.
No worries. I just did. That's okay. No worries. No worries. Okay. All right. And so let's go on the record in the matter of the City of Wyandotte versus Tracy McKenzie, 232253. And counsel?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client, saying to the matter being heard via Zoom.
Thank you. Ms. McKenzie, your name, please.
Tracy McKenzie.
All right. So this is the date for sentencing on Ms. McKenzie's plea to possession of drug paraphernalia. And she was screened regarding her eligibility in the treatment court. And counsel? Mr. Shemke, you're muted.
I'm sorry, Judge. May I please have a breakout room with Ms. McKenzie?
Okay.
We're not ready. Okay. While she waits, we've got another. Let's see if I can bring up. I think we got Judge Jason Elmore's personal meeting room, Wexford and Misaki Circuit Court. Let's see if we can bring this guy up.
Okay, so I'm going to show you where they went.
She's not in the breakout room yet. Kick her out. Kick her in the breakout room. Never mind. She's not going. All right, let's go here.
You can't join, okay?
We're still waiting here. Try to run 3 different feeds so I can follow everybody.
Sorry, Ms. Ruffalo, go ahead, ma'am.
Sorry.
It's okay.
Your Honor, while I understand the position of the prosecution, I would know that it is an unpublished case, and therefore I don't believe it has any binding authority on this court. Additionally, I do believe under the principles of People v. McGraw that this conduct by Mr. Gray, I don't believe it has any relation at all to the sentencing offense. And so I would ask that there not be 10 points scored for OD 19.
Thank you. One moment, please.
What's up with the Iowa teens that killed their Spanish teacher over a bad grade? What's happening with them? They get sentenced? Ooh, they did.
All right. Well, underneath People v. McGraw, MCGRAW, offense variables may not be scored for conduct that occurred after the completion of the sentencing offense. It continues, unless provided for in a particular variable. That was noted by a Michigan Supreme Court case, People versus Smith, 488 Mich, specifically page 197. In that Supreme Court case decision, it stated that aggravating factors considered underneath offense variable 19 do contemplate events that almost always occur after the charged offense has been completed, and the express consideration of these events explicitly indicates that post-offense conduct may be considered when scoring offense variable 19. The thing here is when looking at balance, which is not necessarily binding, it's also based in part off another case. Or I'm sorry, there's another case.
We're deep in the weeds here. Deep in the weeds.
People versus Wall.
Let's see if we can find something a little less case law reading. All right. Our other option is if we want to go back and see. A year ago, we started doing this with Daryl Brooks, and Daryl Brooks had a very interesting judge. That judge, who some say should be a saint, has been hearing the eye drop case, which I think is over now. I think the sentencing is done. We could go back and watch that together if you'd rather. I'm losing my voice again. I thought it was great, but the more I talk, the worse I go. Oh, Megan Fox is interviewing Greg Anderson. That is awesome. That is really cool. Yes, on Doro. I'm going to look now on the Facebook. Let's see. The problem is I'm not on my page. I'm on my account. Is it the kitty picture? The cat and the dog picture? Tash, we'll see you. We're still trying to figure out what we're doing today. Hoping something works a little bit better. Let's see. Judge is back.
The alcohol or drugs unless prescribed, you'll be subjected to random testing as well. And so those are the terms and conditions. I'm going to have Courtney zoom in to speak with you in a breakout room. Can you have Courtney zoom in for me, please? And then she can tell you what your next steps are, okay, ma'am?
Okay, so as far as the tether goes, can that come on today?
She'll give you all that information, okay?
Okay.
Right now you're tethered to treatment through the Wayne County Jail. So that's, yes. So we will, she will give you all that information. How are you doing in treatment?
I'm doing good. I've been here since the 7th, so.
Okay. All right, and the court will also note that there will be a $200 fine, $100 screening assessment fee, cost of prosecution $200, crime victim assessment fee of $75, justice system assessment fee of $50, program oversight fees of $640. So a total of $1,265, and that will be payable through the treatment court. Okay.
Okay.
Judge Middleton is not live.
Okay.
It's really quiet this morning.
I'm going to have you have just hang on for just a few moments, and then we will. I'll put you in a breakout room with Courtney. Okay.
Okay. Thank you. I appreciate it.
All right, and we look forward to having you in the treatment court.
All right. Thank you so much.
All right. Thank you. One moment. Let's go off the record. Good morning, Ms. Braves.
You're muted. Oh, they went off the record entirely. Makes it a little harder. Let's see. Are they done talking about case law?
Your question is better presented as an argument for what I do at sentencing, because on the pre-sentence investigation report, I can't give him credit necessarily for time that he's not owed. So as far as your comments are presented as an objection or request to correct CFJ 145 page 2, I'll decline that or deny that. But I think what you need to, what I think you really need to do is, which I think is probably better, is you can make that argument when it comes time for sentencing, that when I do provide credit. Because if I were to amend that, the Department of Corrections would just kick this thing back and then tell me I've got to correct it again. So I'm not going to deal with them sending it back to me. So again, denied as to amending the pre-sentence investigation report. However, I fully anticipate you should make that argument when it comes time for allocation.
Your Honor, if I can address that as well.
Yeah.
I would also draw the court's attention to offense 24 of 24. He was under sentence as well, 45 days jail. So September 27th as well. And I don't know if that included he got for that, but it does appear there was another sentence that he served as well.
Okay, let me take a look. So I'm looking on CFJ 284 Alpha, page 16,
correct.
Looking at conviction, or sorry, criminal history entry 24 of 24. This is out of the 84th District Court. He was sentenced on September 27th to 45 days.
I'm guessing it was probably a time served sentence, but
yeah. So it ran concurrent prison. So that's just another reason why the court would not be required to grant credit. Well, yeah, because he's arrested on August 10th, in the middle of that date range from June 22nd till today's date. That's just another reason why the court will deny the request to amend CFJ 145 page 2. All right, any other corrections or amendments, Ms. Ruffalo?
No, Your Honor, thank you.
Allocution then, Ms. Ruffalo.
Thank you, Your Honor. As the court anticipated, my first argument here today will be that Mr. Gray, I believe that the court should use its discretion to award him time credited throughout that period of time that he was and still is in the Michigan Department of Corrections. Excuse me. Like I stated before on the record, Mr. Gray, the only thing keeping him in prison right now, he's past his earliest release date, would be the completion of a advanced substance abuse treatment class, and he was unable to get into that class until recently. That is the one thing I believe keeping Mr. Gray in the custody of the Department of Corrections. He is set to graduate next week from that advanced substance abuse treatment program, and while he has been incarcerated, has gotten a employment position within the prison as a porter, and I had to ask him what that means, and he said essentially that's a janitor position. And so he has been working his program, Your Honor, and I think that's the goal based on what's written in the PSI, but also in speaking with Mr. Gray, the ultimate goal here is to get him to the advanced substance abuse treatment. He was able to, at one point, be sent to TRICAP, and he was not able to finish that program. But this, Your Honor, would indicate the first successful completion of substance abuse treatment for Mr. Gray. And with that, Your Honor, I believe that there's truly a mindset change. As Your Honor knows, this case has been going on. It's been open for just over a year. And the way that Mr. Gray is speaking about his time after prison is telling. It's different than when we first spoke. You know, he wasn't he wasn't as, he didn't really throw himself into the network that he could have with the substance abuse treatment. And I do believe it's his full intent when he exits prison to remain sober. He does have a, excuse me, he does have a stable residence to return to with his mother, who is a support to him. Additionally, Your Honor, he has a job lined up at Beyond. He's worked there multiple times in the past, and he has had a couple conversations that indicate that he may be, well, not maybe, but it is anticipated that he will return back to his job at FIAM. I would note, Your Honor, that there were some successful completions of probationary periods for Mr. Gray. However, I do acknowledge that recently there have been some unsuccessful discharges. It is my belief, Your Honor, that Mr. Gray will be out on parole after this, and he is still under the custody of the Isabella County with the Department of Corrections. He is set at this point in time to go in front of the parole board.
Okay,
on December the 11th.
We're going to turn this one down here just for a minute. I'd like to go a different place. One of the trials we're following and have been for a while that we'd like to follow more closely, I mean in person, is the Corey Richards trial. And during our last case, there was a hearing in that trial, and it was about a letter called the Walk the Dog letter. Pickles and Zoe the cat and dog, welcome to the gallery. Thank you very much for continued support. Rebus Kittens, welcome as well. What I think we want to do is go back and watch that hearing. This is, for those that don't know, excuse me, the Walk the Dog letter was a letter that Corey allegedly wrote while she was in jail. That was a note that she, all your mail going out gets read. And the letter was not mailed. It was written and potentially shown to a visitor through the glass. Like she brought it to visiting, held it up to the glass, they read it, she took it down, and then she was going to destroy it, I think, but she didn't. She didn't destroy it. It was found in one of her books in a jail cell search. And so this letter is filled with instructions from her to people as to what to do regarding her case. It looks like all sorts of witness tampering and illegal written all over it. My voice is going out. It's going fast. So I think what we're going to do is bring that up and play that video as we get to listen. This is a case that's out of Park City, Utah. It's in the same courtroom as we had the ski trial with Gwyneth Paltrow. So we're going to be the same courtroom there. It's a fun little hearing. It's about 2.5 hours long, and they argue over it, and it's pretty good. It's hilarious, really. I think it's hilarious. Let's see. It's going to be on channel 7. Let's bring this up here.
I don't think that would be misconduct. I don't think so either, and here's why. But I don't think that would be misconduct. I don't think so either, and here's why.
Let me get the audio working.
If they had formally charged her, she would be given due process rights as it relates to the alleged witness tampering, right? We would be able to cross-examine people, she would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witness tampered. This isn't the first time she witness tampered. This is further evidence of witness tampering. All of those things. And then they go on to say, not only did she witness tamper, but because she witness tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but
this is Corey's lawyer
and
right
that's
here.
The violations of rules 3.4, 3.6 in the UDA standards is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right? And she's going to get a preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, you know, if they had charged her with it, you're right. But also then have the opportunity to refute that or go through due process rights. But by just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witness tampered as a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
and they're
pause
tying
there
all
for a
of
minute.
this together.
A lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive, there was poisoning, caused the death of her spouse. I mean, that's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into because, their justification for the request is we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say they have a theory, right? It's in the probable cause statement. It came out in testimony at the detention hearing. You're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through. Okay. The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps a potential theory of the defense as a false narrative, that it's a lie, okay? Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, you know, a jury pool is going to say, well, I mean, she witness tampered, so obviously these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem, and the rules specifically prohibit the state from commenting on the theory of the case or on alternative theories of the case or on the credibility of witnesses.
This has not gone to trial yet. This is all pre-trial stuff.
Trying to determine where the line between permissible advocacy and
the case will be next year,
communications,
I think, at the earliest.
Irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you. I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm going to answer this in 2 ways.
Sure.
Okay, the first one is, I want to address first, is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right?
Okay, let me back up here for a little bit. For those who aren't familiar with this case, this is a crazy case and one you'll want to follow. Okay, the lady here on the left. Let me see.
If the government's saying she's
the lady here in black on the left that I'm moving my mouse around, this is Corey Richins. If she looks familiar, it's because you've probably seen her on, I don't know, Good Morning America, one of the morning talk show TV shows, because that's where she was a lot. She did the full circuit of the morning shows because she wrote a book. She wrote a children's book about death called "Are You With Me?" or "Are You Still Here?" or something like that. Okay, she wrote this book for her kids because their dad died. The only problem the state has with this is that they say that she killed him. So she killed him to get access to the money so she could spend it the way she wanted to. And then she wrote a children's book for her kids on dealing with grief. at the terrible passing of their father. And yeah, so she did that. The book was like a bestseller. She was all over the place. And then she now has written a letter. And let's see if I can bring this letter in really quickly for you. Let's bring this over. Send it somewhere else. How about here? Send it to the MacBook. There we go. Let me show you this letter really quickly. I'm going to try to read it, but my voice is shot, so give me a little space here. Back door. Okay, we're trying to get it. Why is it not there? There it is. Okay, here we go. Okay, we'll bring this over here. The letter. Yeah. Oh, sorry. I have to unlock the Airbnb. 1 second. Okay, there we go. All right. This letter, my wife is making me a drink right now. Vicky, thank you very much. Thank you. It's going to be a lemon drink. This is the letter, the walk the dog letter that this hearing is really all about. This is a page that she allegedly held up to her mom through the glass. Okay. It says, walk the dog, but take vague notes so you remember. Okay. I don't know what walk the dog means. Page 1. Sky is saying, I think the attorney, even if gummies had fentanyl in them from the prosecutor will say I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them though. However, she wasn't to link Eric getting drugs and something from Mexico, so we need some kind of connection. Her private investigator is doing some research on the ranch cartel place Eric would stay at. Here's what I'm thinking, but I have to talk to Rooney. He will call probably to have you testify in court to this. Okay. He will need to tell Sky at the meeting next week, upon information and belief, just like they say, a year prior to Eric's death. She's literally writing what she wants a witness to tell her lawyer. Okay. A year prior to Eric's death, Romney was over watching football one Sunday, and Eric and Romney were chatting, I don't know, about Eric's Mexico trips. Eric told Romney he gets pain pills from fentanyl in Mexico from the workers at the ranch, not to tell me because I would get mad, because I would say he just gets his high every night and won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in a little allergy pill bottle in his work truck so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Corey to go down for him. When they traveled, Eric would put his drugs in Corey's bag at the airlines right before they boarded. That way, if they were caught, Corey got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag and it would cause a huge fight. She was pissed that he would risk her going to jail for his drug use. He just would laugh about it. Eric couldn't ruin his image, that he had drug issues, that she would do whatever he had to do. Corey's writing this, okay? Corey has never done any type of pills, didn't like them. Rarely would she consume THC, only if Eric begged her because it was a special occasion. Reword this however he needs to make the point. Just include it all. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. He can be short and to the point, but it has to be done upon information and belief, LOL. They never found pain pills or fentanyl in my house because he hid it in the allergy bottle in the work truck. And Cody emptied out work truck within a week, so they were never found. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to Salt Lake and meet him after work without Bree. Sky has to make a connection between Eric and Mexico because that makes the most sense in her mind. If it's Ronnie's information and belief about the conversation over football, she can use that as a connection. Tell Ronnie not to overanalyze it. It was a quick 2-minute conversation. LOL. Tell him I need him to do this. Bring me home, and then we'll get to those dang woo. Also, please text Lotto or call him. Tell him not to text me anything about us doing anything together ever, like church, skiing, trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. Take vague notes of all this so you remember before you walk the dog. Page 4. I saw a commercial yesterday, Utah Mortgage Relief. Google them, please. It's for people behind on their mortgage. Can you see if they can help at all on the Marissa's house, please? We have to get hers, yours, and Chelsea's taken care of ASAP. Try to go to that place in Camas. What about asking Lotto to do a loan solely in his name and not have you on there? I know he can do a home equity line of credit on his house in Hideout. Not sure if he would, but I know he has like $1 million in equity. Maybe he just doesn't know about a HELOC. If he wants to help me, taking care of these loans is the most important. I don't give a blank about the hotels. Remember, I told you one way to get at Katie is going through my phone and finding a picture of her girls, even with the boys. Print 15 copies and send them out anonymously to different media companies. Obviously, don't email the pictures so it's not traceable. She would be livid if it got out to the public. Yes, you could just have to do it. You would just have to do it sneakily and be careful. She would try and trace it back to you. If not, no worries. Sky is having the girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he hasn't been to church in the last 13 years, and she has known him, and Eric would brag to her about how much he drank and did pills in high school. Tell Kelsey to say Eric always wanted Corey to go down for him. For example, he would put drugs in her suitcase when he would travel together, so if anyone got caught, it was Corey. He would put it in her bag right before they left the house, so Corey didn't know. Then when we would land wherever, Eric would take them out of her bag, and Corey would be pissed, and they would argue about it. Tell Kelsey to say how Eric didn't care and would just laugh about it and say, well, I can't get in trouble, as if it was okay that I got in trouble. Have Selma talk about Eric in Spain not being able to drink, so he was looking for drugs the entire time, and explain the drink the waitress gave him and how I called his doctor and went to the pharmacy immediately. Have Allie talk about how the sisters have always been jealous of me because anything they could do, Corey could do better, being a mom, college, stay-at-home wife until she built a $1 million company, a nice house, car, everything she had they wanted. This comes down to jealousy, money, and Eric's partying that they don't want to acknowledge, and sadly on an accidental overdose. Lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it to use in our defense. Would you buy a box of Crest White strips, open them, put them in an envelope, and have Sky give them to me? You can tell her what's in the envelope. I'm sure she won't care. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee and tea all day. I love you. I love you. I love you. Hang in there. We're getting there slowly. You're best. You're the best mom in the whole world. I'm so lucky to have you. Sorry, I left that up the whole time, but thank you very much. This is a letter that's written from a defendant in court. Sorry, you could not. I was showing the letter over here. It's been a rough day. This is a letter written by a defendant in jail to her mom to read, not mail it out because then the guards would read it. So it was held up to the glass so the mom could read it. She could take notes, and then she'd take it back to the jail and then destroy it so no one knew about this. Well, It was found in a jail search before she destroyed it. She wasn't able to flush it down the toilet or whatever she had in mind. So that is what's going on right now in this case right here. So because of that letter, there's this hearing, and we're talking about the walk the dog letter. Oops.
At the end of the detention hearing, it seems like it's 3 times longer.
He has such
now.
a low voice.
I'm with you. I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm going to answer this in 2 ways.
Sure.
Okay, the first one is, I want to address first, is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is a potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean...
But it was everywhere long before this.
It was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not going to sit here and say that all of, this wouldn't have happened or there wouldn't have been news stories. Sure, there would have been news stories about this case no matter what we did, and I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter, and the news stories have run with.
I mean, I have assiduously tried to avoid news coverage of the case just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I've bumped into the cover of People magazine, which seems to indicate or have at one time been providing a counter narrative that seems to be provided by the defense side of the debate. I mean,
I think
why isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she, told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're going to do it through briefings throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we've pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably going to get some of those, but the state has taken it a step too far. And the other thing I want to address is there was an alternative method to this. And in the ABA comments, this was the second part of your question, 2 questions ago, regarding, if they think she witness tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they make in their brief. The second problem is it should have been, our position is it should have been done differently. And the ABA comments speak directly to it, and it's 8-2 point, one second, I'm gonna get there. I can only remember so many numbers. Point 1, and what it says is, a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard 8-5.2.
In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get a fair trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that. I
mean, can we just acknowledge that during trial, the options are so limited. The jury's already in the box. We can't re-impanel.
Right.
Jeopardy's attached.
Right.
I'm paranoid she's going to step in that hole in the floor.
A different scenario.
It's
I
going to
think
happen.
some of the
I'm
cases,
literally nervous about
though,
it.
that came back on appeal, right? Like, it didn't get dismissed during trial. The conduct occurred, prior to trial. And those cases came back on appeal, for a new trial.
Those were embezzlement kickback side deal, right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, or it's difficult in these cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and the statements they have made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial doesn't matter. At this
It matters a little bit, doesn't it? Because if it were to come
I'm going to argue it
trial,
matters because I'll probably move to motion to suppress it, but.
well, sure. Yeah,
Right.
So, and I'm not expressing an opinion one way or the other about any kind of motion in that regard, but imagine the letter came in at trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
The problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations.
Sure.
Right? And yes, we can get to that through cross-examination and
if it comes in.
At trial.
Right.
The problem is that
she's just standing with high heels right next to a hole in the floor.
National,
That's
global
all.
Media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Corey's lying, that her witnesses are lying, that her theory is false, that's the problem. The problem is their statements and the way they've interpreted and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, you know, the way in my opinion, the way it should have been done, or the state's, or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter under seal. You know, we could have had this argument, or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems, and those aren't going to go away. Forever there's going to be this issue that the states said that, and they can't do that. And if the courts, and I granted, dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue yet. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation with media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this,
so we expect a change of venue motion.
You know, based on I agree. Unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention. That we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification of the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved. They're going to be subject to whatever ruling they make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting case, making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why, though, on a going forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going forward basis that would be prejudicial to this region?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem.
Okay, so let me just pause right there for a second. This is the whole purpose we're here in court during this day, and this happened while we were watching our last trial. Okay, so it's a little bit older, but it happened while we were in another trial. The whole reason we're here is because the defense is saying, hey, the prosecutor leaked the letter, leaked the walk the dog letter, along with this whole big story about what's going on. And so they're now trying to get them dismissed from the case. They're throwing everything at the fan, it's going to end up with a request for a change of venue. Is my camera flickering? Can't see that. Tell me if it is. Anyway, so she's fighting for all these things. The judge is shooting them down one by one and saying, no, it didn't cause the problems you think it did. The issues with the public already knowing about this case already existed, and basically it's because of what you guys have put out as well. So we're just not buying that.
Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of facts, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation, and this is where it ended up. And if it's
tell me what you mean by that.
Well, they made the ultimate conclusion that she's guilty in their briefing. Okay. And they were involved with the sheriff's office throughout the entire investigation, and they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forth with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they didn't go look for any. I think the implications of...
That's a great closing argument regarding Ms. Richards getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Summit County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that the
Isn't that problematic as well, though? Or are we sending a message? I mean, we'd have to exclude all the jurors that had any sense of that, that were going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we? Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Corey's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses. I mean, we're going to call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world has taken that they're liars because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say it now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, if Ms. Richards testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence.
Fair enough.
Right?
Yeah.
And you could, that is, I mean, that's what we advocate in closing arguments. You can say, you know, we presented this, the jury gets to weigh the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Corey through a lens that she's lying, to look at Corey through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, you know, I'm doing nefarious or criminal acts, is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
Okay.
Let's hear from the other side.
I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay. Mr. Pleasant.
Good afternoon, Your Honor.
State's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazzaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing, and the defense has an opportunity to rebut that case in the filing. They've just rebutted it, not only in their prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have no knowledge of a whole long list of things, including the briefing and media coverage regarding the walk the dog letter and the manila envelope and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can see as very impartial. Summit County Court set a jury in the Gwyneth Paltrow matter that received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than Summit County. can think of 2 pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see some accounting juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I can remember if it was the state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you, sir.
Ms. Lozaro.
There are a couple of things I'd like to address.
Please.
With so answering. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. But they're, I mean, essentially, what they say is it maybe doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll just pull out a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges, right. I agree with you.
But is it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're going to focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't.
So the only reason I raise that is to say, in that alternative universe that I am describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message, she's a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she'd ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably not to
and
too far in the direction,
I don't think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
Okay, but the issue is that they have just declared that she's guilty of it, right? Instead of...
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Love that.
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used the way they've drawn the inference between witness tampering and the ultimate decision that a jury is going to make in this case after it hears evidence is that because she witness tampered, it's a consciousness of guilt. You know, she induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, I mean, it's clear in the rules. It's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase consciousness of guilt in a number of different ways that doesn't say she's guilty of witness tampering. We're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, you know, it's limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged, she violated jail procedure policy. As well, they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative with the state's position on her guilt and the credibility of her witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't handle the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe I don't know how many people, how many arguments are had. If this were a case without a lot of press, okay, if this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, you know, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, nobody would see it, right? The jurors, I be in panel juries all the time that have never heard of my clients and have no clue about anything that happened, and they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for a dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and this start over, or continue forward, that's what I should say, with a clean slate, in order to, put some order back in and, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, the lofty reason a lot of us started doing this in the beginning, because we were going to be a champion for the rules. But, and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars and her witnesses and her counsel, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
Thank you for your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Rich's ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and the breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt. respect to certain explanations made by the defense for certain actions, that no such link exists in the evidence, that defendant concocts a false narrative, that defendant's own handwriting, she attempts to induce her brother to testify falsely, that she is facilitating witness tampering and supporting a false factual narrative, that she is giving her mother instructions to induce her brother to testify falsely, that this may indeed not be the first time the defendant witnessed tampering, and that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richens, her credibility, the credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richens' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that.
Thank you.
What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it. The parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given the pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richens actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial, and these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct at the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richens a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient or dire process to ensure that Ms. Richens does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied in full. All right. Any questions, Ms. Lozano? Mr. Black?
No, no.
All right. Let's move on from there.
Okay, so motion is not denied there. That was the big one. The defense had filed a motion to dismiss the whole case. They're like, look, the prosecutors broke the rules. They went out and told the press that our client's guilty, and they showed this letter that she wrote in jail and released it publicly. And we're just, we're just furious about this. We're furious they broke the rules. Judge, the only thing you can do to remedy this is throw out the charges against my client because of this this horrible miscarriage of justice that's taken place by the prosecutors saying that my client's guilty. Judge says no. Every prosecutor thinks that the defense client is guilty. That's just how it goes, and says no, it doesn't matter that. He does acknowledge it's going to take a long time to seat a jury here. By a long time, it could take a week. It could take more than a week. Summit County, for those of you aren't familiar, Summit County is the county in Utah where a large portion of the Olympics took place. Okay, it's a mountainous community. It's generally considered quite affluent for the most part. Most of the areas are, even though it, probably it changed within the last 20 years. There were areas that were very affordable and stuff 20 years ago. Now it's a rich community. It's ski resorts. It's high-end shops. It's that's where Gwyneth Paltrow went to go skiing, and it has all the amenities that a celebrity like Gwyneth Paltrow would like when they go on vacation. So this is the community that they're going to be seating jurors from. So they're going to have a challenge on their hands if the judge thinks they need to find people who have never heard about this case, because it is a big case. I mean, this woman's face, this Corey Richens' face, has been all over national television and the talk shows. And you can bet that if Good Day Utah or Good Morning America or all these Fox and Friends, I don't know where all she showed up to promote her book tour. Okay, but if she showed up on the channel and did a book tour and then the news broke that she was arrested, you can bet that all those stations covered that as well. So a lot of people know about it. Renee, thank you very much. Love to see that courthouse change to light blue color by your name. Appreciate your support. So they're gonna have some time off from trial. They're gonna have to set aside some time to find a jury that is impartial, that can listen to this and say, your first time hearing about it. Fentanyl, what? We need a completely fair jury, which will be very difficult. If they're not able to, that will be more ammunition in the defense's bag to say, hey, Your Honor, we need a change of venue. The entire county is prejudiced against my client. We need to move this. Let's move this a couple counties away. Let's move it, even Salt Lake County, that's right next door. Okay, that's just across the Wasatch Mountains from Summit County. That might be too close. Maybe it has to go into Davis County, which is just north of that, or Weber County, which is where I went to school. Anyway, so by we I say me. I've been admitted as media on this case. It is something that I intend to follow, just like with Sarah Boone and Brian Koberger. But I would like to be there for this one when it goes to trial. I'd like to be present physically there and do my show from Summit County and have my own live stream from that. So, and yes, some of the big names. Emily D. Baker has been following this as well. I think Peter Tragos has done it. It's going to be a big one. It's going to be a big one. It'll be really interesting. Do you guys want to hear the rest of this hearing to see how it goes? Because we have a bit more happening here.
Let's go to the no contact order.
No contact order.
No contact order. Mr. Bloodworth, you probably had this since when we last discussed this, but
okay, so this is the motion
I am disinclined
filed
to limit
by the
Ms.
state.
Richens' ability to speak to her mother and brother for several practical reasons. First, I've got to swim pretty hard upstream against the First Amendment to enter that kind of work. Second, there are several non-criminal case related issues that she probably needs to be talking to her mother and brother about, and those are implicated in many of the motions and issues that are being raised in the civil cases, the estate case and the wrongful death case. And so if I gag her in this criminal case, I'm prejudicing her in those cases. Moreover, the cat's out of the bag. You know exactly what she's saying to them. All her jail calls are recorded. You have the letter. You're asking for the narrative. I don't understand what the prejudice is here.
Your Honor, let me take a second crack at it, and we'll, in the course of this explanation, get to the prejudice. Your Honor, in a sense, the court has its hands on a dial, and if it turns the dial in one direction, it can amplify the protection against witness tampering in this case. If it turns the dial...
Assuming any has occurred, right?
I'm only going forward.
Okay, fair enough.
Going forward.
Yeah.
If the court were to rotate the dial in the other direction, it could more narrowly tailor the prior restraint. And they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asked for a lot of protection against future witness tampering, which also meant that prior restraint wasn't very narrowly. I think we're at a point now, having all learned a little bit over briefing and argument before today, including today. Based on where we stand now, the state would kind of adjust the dial, accept some risk to future witness tampering in order to more narrowly tailor the prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced in your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother, Lisa, and her brother, Ronnie, regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare her defense. That would allow, in fact, necessary conduct with her mother and brother to prepare her defense, but it would place counsel there to ensure that it was just preparing her defense. Then the order would read, any or all contact outside the presence of counsel will be either through an in-person visit at the jail or through the jail's home wave applications text.
Okay, so he's still going for it. The judge has already said, look, I'm really hesitant to do anything with the no contact order. You're basically asking her not to be able to talk to her mom, okay, or her brother. And she has pending business transactions, real estate transactions. She's a realtor, by the way. Corey Richens is a realtor. She's the only employee of Corey Richens Realty. And he's saying, if I say she can't contact them at all, there are things that she needs to do and has the right to do that would be excluded. So he's like, I'm not going to do that. The guy's still going for it, right? I don't think he's going to get it. I don't remember how this ends. Just to let you know, though, also while we were watching the Maya trial, also in this case, the judge had a hearing and froze Corey Richens' assets. froze the assets and said, first of all, Eric and the estate has an interest in them. And Corey, I can't completely say she can't use her money because she has to be able to pay for her defense. So there has to be some money freed up for that. And and so that's where they're at right now. And we're going to listen to the end of this. Just know that the assets have been frozen. There's a third party that she has to basically beg for money from every time she wants to pay her attorneys. And that's where she's at, or speaking right now. The noise you're hearing in the background, hopefully when this goes to trial, that will be a lot better mics. We're using an onboard camera microphone that's picking up the air conditioning vent. And it's something I can't filter out just because of there's a lot of ventilation going on in this room, probably because of how many bodies are in it.
I say this because there is a monitoring component involved. The state is having to monitor the defendant to ensure going forward there is no witness tampering. And the state thinks the restriction on in-person and texting allows monitoring kind of without gaps. When we get into monitoring hours of phone calls, there are gaps.
Status quo right now, a defendant in the Summit County Jail is given notification when they make a phone call that it may be recorded, right?
Yes, Your Honor.
In-person meetings, are they notified that those may be recorded?
Yes, Your Honor. They are audio and visually recorded. The inmate and visitor are both notified.
And status quo, the inmate can't pass anything to a visitor, correct? Outside of counsel. And we'll get into that in a different motion, but is that correct?
Yes, Your Honor, that's correct.
Okay. So why do we need to be so specific? It feels like the Summit County Jail is providing all the protections you need to figure out what's being said.
At a lot of time after an inspection of the state, which is part of housing somebody, I appreciate that.
And prosecuting them, yeah.
And that risk that we're missing something.
All right. Okay, I understand your position. Thank you.
Thank you, sir.
You'll get the last word.
Yes, sir.
I'm sorry, Ms. Lazaro, is this one yours?
Yes.
Just level with me. Do you think there's any part of this motion that I should grant?
No.
Okay. All right. Is there anything else you want to say about it?
The judge is like, I'm already on your side on this one.
I think it should be denied, and I think that I'm just going to reiterate the problem is that the entire thing is premised on their accusation of witness tampering, which they have failed to prove.
Well, perhaps we can acknowledge that there are several plausible readings of the walk the dog letter.
Yeah, if the court wants to...
One of the several plausible ones would be consistent with the state's version.
Right.
Okay.
And one would be the defense's
Agreed.
version, and...
I guess what I'm saying is, why do I have to figure it out?
Well, you don't, and that's the problem. You shouldn't
Okay.
have to. Like, that's the whole problem with all of this, is they're alleging a crime without any sort of due process or without any sort of evidence to support it. The fact that letter...
There's some evidence, I mean, a letter exists.
A letter exists, yes, but there's no indication in the reading of that letter that that letter could be written in the lens of these are the people who are going to testify. I want them to remember these things, right? And that wouldn't be witness tampering. She can completely do that. Also, that letter was never passed or showed, and the inferences made by the state is just because she held up one letter that she must have was going to do it with this one, and that's the problem. Like, they have not made a showing that even comes close to a probable cause finding for witness tampering. And I think there needs to be some acknowledgement, if the court's inclined to deny that there isn't a finding that happened. this part of it.
I think it's probably more important for me to make no finding whatsoever on that, isn't there?
Yeah.
Okay. I understand your position. Mr. Bloodworthy, further. All right. Issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with her mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or request that defendant have all in-person meetings with her mother or brother with counsel present, and that other communications be monitored in specific ways through technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes, as long as she doesn't do anything that requires a prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not include any threats whatsoever or any other kind of communication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state has it. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so absent some other ruling by the court excluding the letter or suppressing the search that found it. Moreover, the status quo is that defendant's communications with everyone except her lawyer are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Rich's First Amendment rights. The motion for no contact order is respectfully denied. Okay. Anything further there, Mr. Clifford?
No, Your Honor.
Ms. Lazaro. All right. Ms. Lazaro, the motion to enforce order for contempt sanctions, have I sufficiently addressed that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct. Let's turn next to the state's motion to compel good cause disclosures. Ms. Lazaro, can I start with your team on this?
Sure.
Is it you?
Well, I guess until I need a lawyer, it is.
There's a 60-page document. I have no idea what's in it. You claim you assert it's privileged, correct?
I don't. There is a folder or a manila envelope that Ms. Richens kept in her cell.
Right.
That contains a lot of pieces of paper.
Okay.
Okay. As far as whether a document.
Carefully.
Our assertion, yes, is that everything contained in that is privileged by way of it was given to me, it wasn't given to anybody else, it wasn't published, it wasn't, nothing else was done with it. So yes, that's our assertion.
So the defense asserts this 60-page or 60-something page document is privileged. The state asserts it is not and is material to their case because, depending on which version of the explanation you focus on, it reflects a partial factual, partial fictional narrative. Typically what we do is in-camera review and then allow the parties to make arguments regarding the content of the document and then have a legal ruling about whether it is in fact privileged and subject to disclosure if it's not. You have access to the document, so you're in a good place to make those arguments. I can't ask the state to argue about this with one hand tied behind their back. So, do we give the review attorney access to the document with a strict order that the review attorney cannot share any of the substance of the document, certainly not the document itself, with anyone from the state, and then have a sealed proceeding by which your team represents defendant's interests on this issue, the review attorney represents the state's interests, and then I make a determination?
We could do that, or the court could do an in-camera review. We, as a team, kind of really discussed this. This kind of came up last minute as far as putting it on today. And I guess I'll put this question to the court. Part as to how you want to go far enough. Part of our, I think, concern or things we want to address as it relates to privilege is how and where it was found. And if the court is just simply inquiring as to the contents of the packet itself.
Well, but would you acknowledge that just putting a document in an envelope labeled attorney-client privilege and handing it to your attorney and no one else, that's not sufficient. If you put a takeout menu in that envelope and hand it to your attorney, the takeout menu is not an attorney-client privilege communication.
That's correct. It wouldn't be, but this isn't a takeout menu. These are her handwritten notes.
I know, but I don't know what they say. So if they are, in fact, a fictional narrative where she's just writing a short story, I'm not sure they're privileged at all.
Well, I think
but I'm also not sure they're materials either.
I was going to say, I think it needs, before anything, whether it's reviewed by the court in camera or whether it's reviewed by Mr. Jordan, I think there needs to be a twofold analysis as to what and what not is privileged, and then what and what not may or may not be relevant before it's turned over to the state for review.
I agree. What I am reluctant to do is make that determination in a vacuum without the benefit of advocacy by the defense and the state. And so I agree with you, though. It's a two-part determination. And the privilege issue is a gate. If I determine that it's a privileged communication, it does not get produced, no matter how material it is.
Correct.
All right, let me ask the state about this. Mr. Bloodworth, you see where I'm headed here procedurally. Any objection?
No, Your Honor, that's what the state asked.
It was unclear to me, though, whether you were asking for the review attorney to just make the call or have only the review attorney brief it. But what we need to be clear is the review attorney would have access to this, would be the state's agent, would represent the state's interest, but none of your team and none of your office, nobody else in the executive branch could have access to the document or disclosure of its contents. And
Correct,
so
Your
that
Honor.
made the ruling.
Your Honor, I back off a little bit of what you said and say the review attorney is not the state's agent, he's a neutral. He was selected by the defense counsel.
Not in my proposal. My proposal is the review attorney represents the state on this issue. Because Ms. Lazaro and her team are going to be making advocacy arguments on behalf of the defendant that I imagine go in the opposite direction.
Well, Your Honor, I imagine the state, too, would present advocacy on its behalf, at least to the threshold matter of privilege.
How? You won't know what's in the document. So you need a lawyer that has access to it, and it can't be a member of the litigation team.
No, Your Honor, to some degree the state does know what's in the document because the listen to jail calls where the defendant describes in great detail what's in the document. And that
Maybe, but we have no idea if that description is accurate or not. The document speaks for itself.
Correct, Your Honor, but how the review attorney interprets the document will depend on some measure in the defendant's characterization of it. So the state...
Fair enough, and so will the defense have to navigate those waters.
Yes, Your Honor. The state envisioned and asked for a procedure with the review attorney for the court. We asked for it in the alternative, whereby both the state and defense can present legal argument based on whatever facts they know as to whether or not particular material inside the envelope is privileged. And then he can make a threshold determination on privilege. And then once we're past that, there may be a material determination.
It's not the way this usually works. I mean, candidly, where you're describing hamstrings on both sides. I'm not even sure it would be reviewable if we did it that way. Why wouldn't we just have the state designate, I imagine it would be outside counsel, who for this specific task is walled off from the state's prosecution team? When I represented members of the media, this is how we did it. Right? Like, I can't share any of this information with the reporter, but I can argue why they should have access to it based upon the content of the document. Where do you see the error here?
Your Honor, the state's agreeable to pursuing it in the fashion the court described. I've seen it work both ways. I think what you described is perhaps more common in civil litigation context than in criminal one.
Sure.
And I'm fine to proceed, the state is fine to proceed in either fashion. The state's, the thrust of the state's argument is material needs to be reviewed by a neutral. The defense alone cannot make the privilege determination.
I don't disagree.
And whatever procedure the court prefers to accomplish that, the state agrees to.
Okay, I appreciate that. Have a seat. There's a lot of chatter over there, Ms. Lazar. You feel like we need to go in a different direction?
Just, I guess, 2 points I'd like to make. Given that the court is viewing the review attorney as an arm of the state, our preference would be that the contents be reviewed in camera for at least the initial.
Maybe I'm wrong about that. Forgive me. The existence of the review attorney, their identity was new to me until I read the briefing on this issue, right? And so it doesn't have to be the review attorney, but what I'm trying to avoid is, on the one hand, the court making this determination without the benefit of the adversarial process.
And we're not asking for that. I agree with the court's proposition as to how to move forward, and that it first get reviewed for privilege, and then we address materiality of it. I don't think when we're talking about the first step and the privilege, if we're arguing about whether or not certain things contained in there are privileged or aren't privileged, the state, the counsel here today, should not be able to make those arguments because it negates the whole point of privilege.
That's my point.
Okay.
And so that's why I think they, in my version of the procedure, need to have an outside lawyer whose sole role is to make those arguments on behalf of the state.
Right.
Okay, so you guys following what the judge is saying here? When they searched the jail cell, when Corey Richardson's jail cell, they found a manila envelope. And on the manila envelope, in big bold letters, it said, "Attorney-client privilege documents, no peeking for lawyers' eyes only." It was basically it had all these notes all over it. Okay, so basically saying, don't look in here. Legally, it's protected, and there is a legal protection for attorney-client privilege documents. The jail can't just go in and read them and say, hey, I wonder what's going on. The prosecutors can't just go and say, well, we'd like to see what you told your attorney last week. That's privilege, and you can't do that. Okay, so this all comes about at the time that they did a search of her cell, and they found something allegedly which was not in the envelope, which was this walk the dog letter. It was supposedly in the pages of a book, if I remember correctly. So the judge is going saying, hey, just because you have a nice little envelope you can stuff documents in doesn't mean everything inside there is protected. So the state's saying, hey, we want to have a look because we think you're hiding stuff in there based on what we've seen, okay, based on the letters, based on the fact that you've taken letters and held them up to visitors, your mom when she was visiting the jail. Based on all this, we think you're hiding something. But here's the problem. You can't have a member of the prosecution go in there and peek through and say, oh, well, yep, you're right. Those were all protected. But guess what we learned? Guess what? Well, we just saw that we'd overlooked this area. When we read these notes and found out they were protected, we'd completely overlooked this area of evidence that you were hoping we didn't find. But now we found it. We can't have that. The judge is saying, if you guys are saying we need to be able to force this disclosure of these documents, we need to have this intermediate group, which it might be the judge, it might be in camera, it might be this, this representative group, and the judge wants both sides to be there to be able to say, no, that you're reading that wrong, that's actually a story, or yes, that's clearly admission of guilt, and that's, writing a letter to her mom, saying XYZ. So he's trying to wade through this legal minefield, because if he does it wrong, then there's going to be an appeal, and that evidence will be thrown out. Okay, and he doesn't want an appeal. No judge wants their case to be upheld on appeal for whatever reason. So reversed on appeal. So he's trying to carefully walk this line and say we need to find out what is good and what isn't based on this. I will say for those who are very interested in the Maya trial, right now I think, or in the very near future. Greg Anderson is going to be doing an interview with Megan Fox on her channel. As always, just like with Discord is not my Discord. Megan Fox is not my channel. I don't tell other streamers how to run their channels. I don't tell Discord how to run their page. So if you'd like to watch that there and you're curious, I think that's going to be starting here in just a little bit. And so I just want to let you know, because that is going to be live, and that would be something really cool if you're still interested in that. I'm going to continue playing this, and I don't fault you if you go over and watch Greg when he pops on there. I don't think he's on there yet, but anyway, so I just wanted to give you a heads up there. So we're going to continue as we are going to be following this case when it actually goes to trial, and hopefully I'll be there in Utah for the duration of it as well. So here we go.
And we have identified Mr. Jordan as an agreed upon review attorney.
Okay.
As it relates to that. So I guess I'm envisioning probably two separate processes. We have a hearing on, or at least briefing on privilege, and then a briefing on materiality.
Yeah, maybe we can just do it all at once. I don't know.
Well, I guess, yes. Well,
if you're going to review the documents,
that's
we're
fine.
briefing this.
That's fine. The other thing I just think is an important, like a side note, and this is probably going to come up in the briefing. The jail searched that packet multiple times and passed on everything in it. It was, and I'm just bringing that up as, and like I said, it'll probably come up in argument, but they've already, they have been through it.
I'm not sure what the significance of that is, but I don't know that I need to.
Yeah, we don't need to get
now.
into it today.
Okay. All right. So.
Do you have any other questions?
No, I have some practical questions for the state. And if you're not prepared to answer them right now, Mr. Bloodworth, I'll understand. I'm just moving this issue in a direction maybe you didn't anticipate. But are you prepared to stipulate that the review attorney, Mr. Jordan, will be the state's attorney for the purposes of this walled-off review of the 60 whatever page document. Or do you want to designate a different lawyer and keep the review attorney separated for future tasks? Maybe
Your Honor, I want to consult with my team briefly on this, and part of the reason why is the review attorney is already engaged on other reviews.
Right. Okay.
And so my sense is we need a new attorney.
Maybe so.
That I don't want any of his other reviews to
Be affected. Okay. Why don't we're going for about 90 minutes. Why don't we take a 15-minute break?
Before we get there, can I just make one more point?
Sure.
I think before we get to the point of whether or not they're privileged or not privileged, we need to address whether or not we should be compelled to turn it over to start with.
That would depend upon materiality, right? I think that's right.
I mean, I think the state needs to make a showing as to why they think they get this packet, first of all, right?
Well, all right, so let's put aside any issues of whether the way the document came to the state's attention is appropriate, should be suppressed, excluded. Put that aside. I don't have any motion like that in front of me.
Okay.
The state knows about it. They know some things that Ms. Richards has said that they think refer to the content of the document. Don't know whether or not they're accurate. We'll find out. Whether the defendant has to turn it over under Rule 16 will depend upon whether it's material, right? Whether there's good cause for the disclosure. Hypothetically, if she's like, here is a timeline of how this went down, and just gives a list of admissions, and somehow it's not privileged, right? That's the kind of thing that would need to be handed over. If it's, here is a short story about carriers, I'm not sure it's the kind of thing that needs to be handed over. Do you see the law differently?
Well, I guess in my mind we need to go back a step. I mean, we're talking about whether or not things are privileged or not privileged, and then if they aren't privileged, whether they're material. Before we get to that, I think the state needs to provide a good cause showing as to why they think they get it, and I think it doesn't. Before we ever get to any of those steps, like
I think they would say they have a sufficient threshold to trigger the privilege review based upon portions of the recordings of Ms. Richards' jail calls in which she says this is part fictional, part factual. Am I summarizing that correctly, Mr. Bloodworth?
Yes, Your Honor.
And so there's a reasonable inference in the state's view that the parts that are factual are backward-looking statements about what happened. They're factual. We'll find out. But there's at least enough that the state has presented to trigger your need to assert the privilege, maybe move to suppress, I don't know, and then to trigger the related materiality review. You see it differently?
That's fine.
Why don't we take a recess?
Yeah.
Okay, sounds good. Listen, there's a lot of people in here, so if you need to get up and move around, that's fine, but it's 15 minutes. So if you don't want to get locked out, consider staying put. We'll be back at 3:20. Thank you very much.
All rise.
Okay, so they're taking a break. I think we're gonna end here on this one. Yes, thanks for the clarification. Greg Anderson, Attorney Greg Anderson, is not talking mostly about the Maya case. He's talking about the Kushner case, which is if you remember back to the Maya trial, the family, the lady they brought in who needed an interpreter to speak. She had a child who was also at Johns Hopkins Children's Hospital who had a similar sort of experience or set of facts in their case. And she testified to the fact that I believe Sally Smith came in with a white lab coat and all that. Or anyway, so that's who it is. He's not there yet. I think he's running late. My voice is going rapidly, and as somebody who who prides myself on making a channel where your audio is really good quality and you get to listen to good stuff. I feel bad that you have to hear the deterioration in my voice. I thought it's just not. It started out okay this morning, and then it's going downhill. Let's see. As far as the trial dates, I don't know when when next year. Yes, it's going to be next year. But I don't know when the trial is going forward. I don't think the date's been set yet as far as a hard and fast trial date. There's just a lot of things that have to happen. They're not ready at this point, but it's going to it's going to come soon. What's your chat schedule this week, please? Carol, we're going to follow some small cases. It's Thanksgiving week, and a lot of judges, a lot of our typical judges that we follow just don't have anything going on right now. There's no courts in session that we can watch. So we might go back and rewatch some stuff that we've missed. But there's just not a lot of options out there that I can bring you. So I don't want to waste your time, but at the same time, I would like to do a Thanksgiving type stream where we talk about the good things, things we're grateful for. It's a tradition in my house that when we have Thanksgiving, we talk about some of the things that have brought us pleasure and happiness and in life, and particularly over the last year. For me, this channel would be a big one, and this community would be a huge one. It's last time around Thanksgiving, we were just barely starting our channel. I believe I had not become monetized yet at that point. So it was a dream, pie in the sky type thing, and it was amazing. So cough, RA, cough. Yes, Gordon, it doesn't help. It just gets worse. I drank some of my wife's brew that she concocted, and it feels better, but it still sounds the same. Okay, so anyway, we're super excited about the Corey Richens trial with this moving forward. I think it's an amazing set of facts. We have her lawyer is phenomenal, is really good. Just remember, not every lawyer who gets up there and stands up and sounds a certain way or looks a certain way is that way. A lot of times they play their cards very, very carefully, and just like we saw with Greg Anderson in trial, he came up and stood and was sort of like the bumbling, forgetful sort of lawyer appearance. That's not him whatsoever. Corey has a fair amount of money. I think there's like a $13 million lawsuit for some assets and things like that going on in her case as well. She has a fair amount of money. She's been able to afford her own lawyer, and this is the lawyer she chose. And she chose this lawyer for a reason. So she's got a very good lawyer. Some of these motions are a little bit weak, legally speaking, where they really didn't stand a chance at all, but every lawyer is going to at least make the attempt just to preserve the record and everything else. So I think that's what we're seeing. I think when it actually comes to trial, I think we're going to see some very, very good defense work. We're going to see some strong motions, probably in the area of excluding evidence. I think that's going to be key in her case because there seems to be quite a bit of evidence that may be problematic for a jury. So we're going to see some of that, and it's going to be fun to watch this move forward. Pam D, good trial recommendation for downtime. Ohio versus Matthew Moore. You will love the defense attorney. Is this a current or existing? And how long was it? Matthew Moore. Let's see. This was last year. It was August of 2022. I'll have to look at that. Bravo Chick, we're going to be on 3 days this week. Monday, Tuesday, Wednesday. And Wednesday will sort of be our Thanksgiving stream, I think. We might say hello on Thursday just as a wish everyone happy Thanksgiving. So, yes, Sky, the lawyer, she is awesome. She's very talented, force to be reckoned with. Tabasco shots, just saying, it's a sixfold. Fixes what ails you. I think think Ian would probably support that, but he'd say Tabasco's too weak. You need to go with something stronger. They are going to try to keep the walk the dog away from the jury. Here's the thing. If they can say this was a story and it's not related, especially the fact that it wasn't shown to anybody, I can see it staying out. I can see this not coming in. But rest your voice and check out the medicated throat sprays. What is it? Cepacol? Cepacol makes a good one. Oh my goodness. When I got strep throat one time, man, just being able to spray the back of my throat, it was like a fire extinguisher on a fire. It was instant relief. It was so good. But it's not sore. I just lose my voice. Stacy, happy Thanksgiving to you as well. Wonderful to have you here. If I would, if you guys wouldn't mind, I would love to. Let me just see if I can do this. Hang on one second. Let me see if this is available. Okay. For those that are interested, we had the Andersons, the attorney Anderson, Jennifer Anderson, on the show, and it was with her sisters. It was amazing. They were incredible. That was a wonderful interview. I appreciate them for coming on. If you're interested in following the interview that Megan has, I believe Greg Anderson is joining right now. We're going to wrap up the show here and patch people over to her channel if you'd like. If you don't, that's fine. But we're just going to make the jump for those who want to. I haven't seen Greg jump on other. I've seen him on like news channels and Court TV and things like that. But it's neat to see him on some of the us little guys. see him talking. He's going to be talking about this upcoming case with the Kushners, I believe, and we'll do that. So. I promise to rest my voice as well and not overdo it while I have time off. Looks like he just barely jumped up live on Megan's case, so I'll patch you over here in just a second. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again. We'll see you tomorrow morning, hopefully with a little bit better voice. Thank you all. Have a great evening. We're going to patch you over to Megan Fox. Please give her a like when you go over there. Just like the stream. It will help her out a little bit. Let's be respectful and be the amazing people we are. And just welcome Greg to YouTube. Thanks, guys. We'll see you tomorrow.